Hello, we are now live for today's webinar. Give everyone a chance to log in. See, people are able to get in the room. Hopefully you can hear me. See the cover slide for today's presentation on New York paid sick leave. And you should also be able to see me in the upper right-hand corner of your screen. Thanks for joining us. Just a couple of minutes and we will get started once everyone has had a chance to log in. So again, I'm Scott Horton. I will be presenting today on New York paid sick leave, talking about the latest guidance from the State Department of Labor and some lingering concerns. We will get started in a minute or two. Hopefully everyone can hear me and see the cover slide for the presentation as well as see me in the video box. If you're having any trouble, it's suggested that you close other applications open on your computer or device, but hopefully everything will run smoothly. Again, I'm just going to give everybody another minute or two to get logged in, and then we will get started. Thank all of you for joining us. You should have access to a chat screen. I'll explain again, but that is where you'll be able to type in any questions that you have. And for the most part, I will answer questions at the end of the presentation. And people are still joining, maybe another minute, and then I will get started. Hope you get settled in. We will try to go about an hour in case you're wondering and haven't been in our webinars before. We typically plan on about an hour, but I will stay on as long as possible to answer any questions that come in at the end. Okay, I'm going to go ahead and get started. Maybe a few more people are still logging in, but I will do the introductory points. Again, my name is Scott Horton, founder and attorney with Horton Law, based in Orchard Park, New York, near the Buffalo area. And I am presenting today on a topic that has statewide applicability. My practice does span various parts of the state, and that is the New York paid sick leave law. And I waited to present specifically on this topic, although we've addressed it in other webinars, because I wanted to talk about the latest guidance from the Department of Labor, which came out at the end of October. Since then, we've been hoping we may get more formal guidance in the form of regulations from the Department of Labor, but as of yet, that has not been the case. With a practical effective date of January 1st, I know everyone needs guidance, so we wanted to go ahead and provide this webinar. Again, we will aim for about an hour, and typically I try to target to end at that time, subject to any questions that remain to be answered. We'll try to answer all questions that come in, at least to the extent they have an answer, and do the best with the ones that don't. I just remind you, first, you can type your questions in the chat feature as we go. Generally, I will wait and answer those at the end unless they happen to be easy to fit into what I'm discussing at that very moment. The other thing to keep in mind is when you type in a question and I answer it, we don't have an attorney-client privilege confidential exchange there because other people are able to see and or hear the question and answer. So if there's something that's very specific to your company, even if you are one of my clients, that will not be privileged in this forum. So just keep that in mind by way of disclaimer. If you have any trouble with this webinar throughout, it potentially a resource issue on your end, so try closing other apps or reloading and rejoining the webinar. With that, let's get right into the presentation. I like to provide some orientation for what we're talking about generally, and in this topic particularly, we could jump directly into the latest from the Department of Labor, but I want to give you a little bit more of the big picture and provide some of the basics of the law itself, which technically went into effect on September 30th. And we will, along the way, also address some of the issues that were either clarified somewhat in the state's guidance or in other cases just made more confusing by the guidance. So first, what I thought would be helpful would just be to note the various paid sick leave laws that are now relevant for New York employers. These vary between federal and state laws and have different scope and applicability. But I just want to orient everyone first by noting that there is the Federal Families First Coronavirus Response Act, FFCRA, which allows the 2 weeks of paid sick leave in certain situations related to COVID-19. And then there is actually, I didn't put it on here because it's not technically a sick leave law, but you all are probably familiar now with the paid federal FMLA leave that relates to COVID-19 because of students who can't go to school because their school is closed. But anyway, what I wanted to point out is while that currently interacts on some of these issues, that law actually expires at the end of 2020. So when people start being eligible for New York paid sick leave on January 1st, that federal law will no longer be on the books. There will still be the New York State quarantine leave available. This is a state law that provides employees various forms of ultimately paid time off with an interaction with the paid family leave program and disability insurance when they are placed on a mandatory quarantine by a government official. So that doesn't expire at the end of the year. Of course, that could potentially interact with paid sick leave under the new law. There's then the New York paid family leave, which, as we'll talk about in a little more detail, does have instances where that could coincide now with circumstances for which employees can take the new mandatory paid sick leave entitlement in New York. And then, of course, finally, there is the New York paid sick leave law, which is a state law applicable to all private employers, non-governmental employers. So it does not cover the state, cities, towns, villages, school districts, municipalities, and most public authorities, for example. It does cover private schools and charter schools and nonprofit organizations, as was specifically clarified in the Department of Labor's guidance. There is, if you are in New York City or have employees in New York City, the New York City paid sick leave law. We'll talk about that briefly at times. I'm not going to go too much into the details of that. As of recently, that law has been amended to make sure that it also satisfies the New York State paid sick leave requirements. But there are a couple of additional aspects of the New York City paid sick leave that you also have to comply with if you do have employees there. Just want to also reference that there are also unpaid leave laws that could overlap with what might qualify as sick leave now in New York. Of course, there's the FMLA, the Federal Family and Medical Leave Act, for employers with 50 or more employees. So there will be situations where an employee can be receiving paid sick leave as required by New York law that would also count for FMLA leave. Likewise, although technically not leave laws per se, the Americans with Disabilities Act and the New York Human Rights Law, both the state human rights law and the New York City human rights law, collectively require employers to make reasonable accommodations to employees with disabilities. And in some cases, the accommodations can include leaves of absence. So in those situations, the law only anticipates it being an unpaid leave, but now you may need to allow people to take leave in some situations because of the sick leave law where they formerly didn't have sick leave available. So there could be some interaction with those laws as well. Although practically now, if they're using the sick leave benefit that your company provides because it's required to, it won't necessarily be as important to do an analysis as to whether that accommodation is reasonable or not. But in most cases, for longer term leaves for disability related reasons, it would extend beyond what the New York state law now requires anyway. Just for reference, there are a couple of other statutory pay requirements where people are not able to work. These are the workers' compensation program, the short-term disability insurance requirement in New York, and unemployment insurance. None of these are technically leave laws, and they don't require you to maintain the employment of someone just because they are receiving workers' compensation or disability benefits. Obviously, if someone's on unemployment, they typically aren't working. But this is just to kind of fill out the picture of the number of laws that can interact, because there are situations under some of these situations where somebody would normally be getting short-term disability or workers' compensation benefits where they now may or may not be also eligible under the paid leave that's going to have to be available, or unpaid leave for the very smallest employers. Okay, again, I said this before in passing, governmental employers and their employees are not subject to the New York paid sick leave requirements. One argument is that that is because most of those employees already have some form of sick leave, often negotiated because they're members of unions in their workplaces. The other argument is that the state didn't want to put this burden on itself. Decide on your own what the reasoning is, but if you're a private company, even if you're a nonprofit, then you are now going to have to deal with this law. The complicating timing aspect of the law, which was passed back in April and signed by the governor, is that the law took effect September 30th in some respects, including accrual of leave, but no one can actually take the leave under the law until January 1st of 2021. That does actually create some complications for companies that had accrual of sick leave or maybe just a more general PTO policy that didn't end and begin at the end and beginning of calendar years, where there might be overlay of two time periods now, and the guidance from the state has not really bothered to address that very carefully. But if there are questions about that, we can try to come up with answers. The apparent concept here was to begin accruing in September so that come January 1st, employees would already have some time available to use, rather than having to start accruing January 1st and then not be able to use the time until they've accrued it. Just briefly, most of you have probably already figured out where your company falls in this whole array of coverage. The smallest employers with less than 5 employees and net income of less than $1 million can provide unpaid sick leave, 40 hours a year, or capped at 40 hours a year, that is. If you have more than 5 employees or sales over net income over $1 million, then you are going to be providing paid sick leave. And just to be clear, there's no government program to reimburse for this money like there was for the FFCRA in the event that it's been something you've dealt with. Here's a question that I'm gonna get to in a minute, but I will answer the easy question first. Do I only count New York employees or all employees? It seems like it's clear that you only count New York employees. So if you have employees in other states, they will not count. We're going to address that in a couple of ways going forward, though. The trickier question comes in, and we'll get to this on the next slide, is how many employees do you have in New York? If you are close to one of the thresholds, under 100 employees with income over $1 million or income of any level and more than 5 employees, you have to give 40 hours a year. For the employees with 100 or employers with 100 or more employees, you have to give 56 hours per year. So if you're really big, it's not a problem. You know where you fall. But if you happen to be right on the border of 5 and have sales under $1 million or net income under $1 million, or the border of 100, then the next slide becomes potentially relevant. So how do you count employees? Well, there was a specific clarification that if you have multiple work sites within the state of New York, then you aggregate those. So if you have 5 employees in Buffalo and 5 employees in Syracuse and 5 employees in New York City, then you have 15 employees. Again, I don't think you're covered if you're outside of the state of New York, except for a wrinkle that will come back up again, and that is for employees who work in multiple states. So once the employee comes into New York and performs work, then the guidance does suggest that for that time they accrue leave. So that's complexity we'll talk about in a little more detail, but apparently they would then count, which can be a factor in this really confounding situation that the law says you count employees in any calendar year, meaning the 12-month period from January 1st through December 31st. Note that for the net income purposes, they reference the previous tax year. So it seems arguable that if you have 100 employees total across the year, then throughout that year, your employees can accrue and use up to 56 hours versus 40, which raises the interesting conundrum of what happens if we have 90 employees for most of the year, but then at the end of the year, business really picks up and we end up hiring 15 more people. Now what do we do? Arguably, I suppose that you have to then retroactively give your employees more sick leave, but how could you now let them retroactively use sick leave that they didn't already have? I think it's pretty surprising that the state did not address that in their guidance. It may be because there's frankly no logical way to interpret the statute, and we wait to see whether there's anything else from the state before January 1st to clarify that issue. If you are right on the cusp, then ideally you're going to be somewhat conservative in your interpretation and apply the broader additional leave requirement just to be safe. But if you can't do that, then you will have to consider how to make changes once your employee count does change. There's a question, is this W-2 employees only? Well, I don't want to answer that question exactly, but it is employees and not independent contractors. So from the legal standpoint, so whether you provide them a W-2 or not, it's probably the people who arguably you should be providing a W-2. Technically, the W-2 is a federal tax instrument, and the standards for who's an employee versus an independent contractor can vary under that federal tax law versus state Department of Labor interpretations. But yes, if you have true independent contractors, they won't count. It's employees. Okay, so let's say you happen to be able to conclude whether you have to provide paid or unpaid leave and whether it's 40 or 56 hour maximum accrual. Well, I'll get back to that question at the end that you just asked about the follow-up on employees. The accrual question is then important. We know what your cap is, or we're assuming you know what your cap is. And then you have to allow all employees to accrue at least 1 hour for every 30 hours worked. This applies to full-time and part-time employees. And while you can front load all of the time, say 40 or 56 hours as of January 1st, and avoid having to deal with accrual, that becomes more complicated for people who wouldn't accrue that full amount over the course of the year. Depending on your circumstances, you may not care, and you may just say, well, we're going to give everybody the 40 or 56 hours day one, and it'll be what it will be. But there are some companies that only want to do that for full-time employees and not part-time employees, which can mean you have full-time employees being front-loaded and part-time employees accruing. One thing the state guidance did clarify is that if you front-load time and say, here you have 40 hours, but then later in the year realize that they won't work enough hours to have earned 40 hours based on the 1 hour per 30 hours worked requirement, then you cannot take that time away. So if you front loaded, it's at your own risk that they won't actually then work the requisite number of hours to have earned it. Some employers, of course, are lumping this with vacation or other forms of personal leave as a paid time off policy, and you generally can do that. So if you already were giving people 2 weeks of vacation time, but now just want to call it 2 weeks of paid time off, you can do that. You don't have to add this accrual on top of existing benefits. You can combine them. Generally speaking, again, unless you have some specific obligations that you can't unilaterally change. So some employment contracts might be written in a certain way that you might not be able to unilaterally modify. If you are in a union setting, a collective bargaining agreement might dictate otherwise, and we'll get to that. But generally speaking, you could change your existing benefits to encompass this new sick leave if you need to. You could also accrue at a different rate for what it's worth. If you wanted to let people accrue an hour for every 20 hours worked, you could do that, but you just couldn't do it for every 40 hours worked because that would not be as generous as the law requires. When we talk about hours worked, we don't have a definition exactly of what that means. We do have some carve-outs from the state guidance now. So if it's, just time that someone gets paid, vacation time, for example, that doesn't count as an hour worked. It's actual hours worked, whether it includes call-in or on-call time or something like that is a little bit more nuanced, and it ultimately depends on somebody's interpretation of whether that counts as an hour of work. I would say the general guidance right now is if it's time that somebody would normally be compensated regular wages for, again, not vacation time or something like that, but where they're doing enough that they get paid for it, then it probably counts as hours worked for these accrual purposes. Okay, so now let's just, again, assume that we figured out how they're going to accrue this time, or maybe even it's front loaded. What happens, for example, at the end of the year? The law does say that employers must allow their employees to carry over unused time from year to year. So let's say you accrue 40 hours in year one, but only use 5. You now start year 2 with 35 hours and start to accrue again. The law, nonetheless, only requires employers to allow their employees to use up to the maximum within a year, so 40 or 56 hours respectively. So it could be that somebody that carries over 35 hours, once they accrue another 5, they have 40 hours, and that's the most they could use that year. However, in that situation, they would still likely be able to accrue additional time that they could then carry over again. Even if they did, say, use their 40 hours that year, they could potentially carry over the 35-hour difference if they accrued another 40. So that then raises the question of what about front loading? If we're going to give, let's say we're a large employer with hundreds of employees, we're going to give everybody 56 hours on January 1st every year anyway. Does it really matter if they carry over from one year to the next? They'd never, and let's just say our policy is going to hold them to the max or the statutory minimum of 56 hours. They're never going to accrue. They're never going to need to accrue more than 56 hours because they're going to get it every year anyway. The guidance allows that makes sense, but it's not entirely clear what you're supposed to do in that situation, other than to say if you then change your model from one year to the next and say, well, last year we front loaded, but this year we're not. Well, then what happens if you didn't effectively track and allow someone to carry over their time? So as long as you always front load, it probably doesn't matter too much. But if you want to stop front loading, that's an issue. There is no maximum according to anything in the law or guidance so far as to what can be carried over, raising the theoretical possibility that somebody accrues over a number of years, potentially hundreds of hours. But again, you can limit them to using only the 40 or 56 hours, depending on the size of the company, within a given year. Theoretically, I suppose somebody could accrue hundreds of hours and then in some year not work and not accrue more time and use sick time, and then still have more sick time to use the following year. But, if they're only using 40 or 56 hours of sick time in a year and not actually coming to work, then it seems likely they're going to lose their job for some other reason, namely not being at work, whether because they don't show up or because they don't want to be there, or because they can't perform the job any longer. The other problem here, though, is there are record keeping requirements. You have to keep records of weekly accrual. It's likely that as long as you front load, you don't have to separately track the weekly accrual, but that is a disconnect in the concept of front loading that's not directly addressed by the Department of Labor. So, probably the best recommendation is, if you're going to front load, is to still track as well as possible, on a regular basis. Certainly how much time people have left, but arguably even how much time they would have accrued if they had been able to carry over from previous years. So just because it's never going to matter doesn't mean that after 8 years somebody couldn't have arguably accrued 300 hours of sick leave. Again, you're going to keep front loading, then they'll never be able to use them. But if hypothetically you stop front loading and there's any risk that they're going to come back and say, we should have continued to carry over the time, then you would have that record. Again, I can't say you have to do that. I'm just saying that if it's just as easy to do that, might not be a bad idea, subject to further guidance from the state. Okay, now what happens at the end of employment? there's no requirement that employers pay this unused but accrued sick leave out, either at the end of employment or even theoretically at the end of the year or when somebody hits a certain cap of accrual or anything like that. It can basically be a use it or lose it, not from year to year because of the carryover provision, but during the course of your employment. However, as has generally always been the case, you must have a clear policy on this, or else the default will be that it has to be paid out. So if you don't have something in writing somewhere, which you're expected to do by law anyway, on whether or not you're going to pay out this unused time at the end of employment, then you should get it in writing. Otherwise, you're going to be presumed to have to pay it out. Seasonal employees, the guidance has told us, are a slight exception to this, in the sense that, suppose, I guess, you have somebody who only works every summer, then from one summer to the next, if they come back as usual from year to year, then they maintain their accrued sick leave balance. I suspect there are going to be situations where it's not going to be cut and dry whether somebody is a seasonal employee or not. Somebody who happened to get hired to work 2 years in a row, but with no clear expectation that they were going to, do they continue to maintain their previous accrual? That's an open question. Here's something else that the guidance volunteered into the mix that's not in the statute: whether employees can donate sick leave to other employees. The Department of Labor says that employers can allow this if they want to. Employees don't have an inherent right to do it under the law. If it's going to happen, it has to be completely voluntary on the donating employee's part. So, employer can't say, if you don't do this, then you're going to lose your job. And probably if there's evidence of pressure from other employees or coworkers to donate the time, and the company knows of that pressure, that might also be a limitation on the employer allowing it to happen. I don't think anybody writing the law was really expecting this to be an issue, but the Department of Labor recognized it could be, and probably because there is a practice in some workplaces, often involving union contracts, of sick banks or leave banks, where employees do donate time available for other people to use. And there's various reasons why that may or may not be a good idea in different workplaces, including, limiting the amount of time that anybody can accrue, where they might get it paid out at the end of employment, or just trying to do good by employees that, for example, won't get paid out their sick time. So maybe let them share. That seems fair. But if this is something you're considering for any reason, you should definitely think through some of the implications, including that one employee with a certain pay rate could donate their time to someone else with a higher pay rate that they could use and therefore get paid more for, and stuff like that. So I'm not assuming that most companies are going to now rush to allow this just because this law took effect. But if there is a reason for it to occur, then the Department of Labor is saying that it could possibly be okay. One of the funny things about this paid sick leave law is that there hasn't been as much focus on when it can be used. It's these other details that have been more complicated and concerning for employers. But just because it's worth covering, I put on this slide the basic situations where employees must be allowed to use this time. And basically, it includes anything involving their own medical health condition, mental or physical, or that of a family member. I'm going to show you what family member includes on the next slide. And it includes not only treatment and illness and injury, but also preventative medical services, even including going to the dentist. It also covers something that wouldn't necessarily be a sick situation, and that is absences related to domestic violence, and we'll talk about more what that specifically includes per the statute. It just also should have mentioned that this will all be available to you, the slides at the end. Sorry, I just paused as the ambulances or fire trucks were rushing by behind my office. Hopefully you can hear me okay still, but the slides will be available at the end. I will make those available, and you will also get an email with a link to those probably tomorrow. So if you're frantically trying to write all this down, it's not top secret. You'll have access to it. And my picture might be covering part of the word child here on this slide. In case you're wondering, that's parent/child. So when you're talking about family member medical situations, family member is defined pretty broadly as a child, spouse, domestic partner, parent, sibling, grandchild, grandparent, or the child or parent of a spouse or domestic partner. And then when you talk about parent and children, that is further explained to be a broad concept, including biological parent and children, foster parent and children, step, adoptive, and legal guardians or legal wards, as well as people who stood in loco parentis when an employee was a minor child. The lists are almost identical for parent and children, but for some reason, one of the lists does not have the word step. I don't know if there's some logical reason why, and I can't honestly remember which one it is. Either step parents or step children are not specifically listed. I think it's step children, and I don't know if the legislature intended you to have to be adopted or to be a legal guard or legal ward before you qualify for coverage. But I think for all practical purposes, we understand that it's pretty much any of these things. The safe leave, which is what the Department of Labor guidance, although not the statute, refers to the domestic violence situations as, are listed here. Again, it's pretty broad, and I don't necessarily need to read all of them, but basically if someone is involved in a situation where there may be an instance of domestic violence and they're trying to get services related to that, legal or otherwise, then they can use this sick leave time for that. The guidance does make it clear that the allegation of domestic violence does not have to have been raised even with the police department to qualify for this type of leave. I'm going to go ahead and answer another question that had come in about paid time off bank, PTO bank, or separate vacation and sick banks. What's better? I don't want to generally say what's better because there could be reasons why there's something different in a particular workplace. But if you look at this sick leave policy as also having to encompass this safe leave, it just starts to get you down the path of, it's more than just the employee being sick. It's more than just a family member being sick. It's going to include going to the dentist and that type of thing. I'm going to show soon some other limitations on figuring out exactly why the person isn't at work anyway. It does all kind of lead you to the conclusion that if there's not some better obvious reason not to do it, wouldn't you just lump it all together as paid time off? And there's nothing from the state stopping you from doing that. The one scenario I've seen come up is where people want to require additional notice for vacation time or put additional limitations on its use. For example, we don't want you to be able to use vacation in 4-hour increments, which you'll see you have to do for sick leave. So it can be that there's a reason to separate out vacation from other forms of leave that would qualify under this law as sick leave. But you can write your PTO policy, I think, in ways that would allow you to still treat vacation time a little different, but still counting all towards the same bank. So again, there's different reasons, but yeah, the way the law itself is written, it makes it hard to really understand why the person needs the sick leave in the first place. And here is exactly what I was alluding to, that the employee has to request sick leave before taking the time off. They can't be required to provide that notice at any particular amount of time in advance. So as long as they let you know before they aren't at work that they need to use sick leave, they have to be able to use the sick leave if they have the time available and haven't already exceeded the maximum annual usage. You can allow employees to use the leave even without prior notice. For example, somebody doesn't show up for work, but it turns out it was because they were having a medical emergency. Kind of stands to reason that you would let them use their sick leave for that, but I suppose technically the law doesn't require you to allow it if they didn't let you know before they didn't show up. The other confounding, in some sense, aspect of the law is you can't require the employee to disclose confidential medical information or information related to safe leave circumstances as a condition of taking the sick leave. So you're going to be very limited in your ability to get any sort of clear documentation about why the person didn't come to work anyway, which is another reason why it might make sense just to let it be lumped in as PTO. The other issue that I had just alluded to, the leave increment, the statute says it must be reasonable and the minimum increment can't be longer than 4 hours. A lot of people would read that together and say, okay, so I can have an increment as long as it's no longer than 4 hours. So I can't have full day leave requirements, so we'll do it in half day, essentially 4-hour increments. I think that's probably fine, but again, the statute does also say it has to be reasonable. I guess if someone could argue that 4 hours isn't reasonable in a certain situation, we'd have to see what the state would say about that, or a court. The last bullet on here, must provide written notice of any restrictions regarding increments and total annual utilization, means that the employer must do that. So in a policy or some form of posting, if you're going to require that sick leave be taken in 4-hour increments, then you have to notify the employees of that in advance. Otherwise, I guess theoretically they can take it in minute increments or arguably less. So again, there's not a specific requirement that employers have sick leave policies or paid time off policies, but effectively, because there are various notice requirements, you should have one. Otherwise, anything you don't put in writing will be interpreted in favor of the employee. And this actually goes also to that annual utilization. So while the law says you can limit employees to 40 or 56 hours of sick leave per year, respectively, depending on the size of the employer, you have to put that in writing or else there will not be a limit. The statute itself does not implement that limitation, just says you can. The rate of pay, in many cases, is not that complicated. It's just their normal rate of pay, but the guidance does clarify that you don't have to add in overtime. So just because, they would have otherwise worked over 40 hours in a week, for example, or they normally do, The time they use for sick time doesn't have to be at time and a half or some other overtime rate. In the case of restaurant employees, for example, or others who normally receive tips, you don't have to make up for lost tips, but you also can't apply a tip credit. So restaurant service workers, for example, can generally make less than the state minimum wage on the theory that they're going to also receive tips. But for sick leave purposes, you can't just give them that lower tipped minimum wage. You'd have to give them the full minimum wage for the hours they use sick leave. The other point that the guidance makes is that when you have an employee who works at multiple pay rates, normally you have to take some weighted average of those pay rates when calculating the sick leave rate. So if, for example, somebody normally works half their time in a job that pays $15 an hour and half their time in a job that pays $25 an hour, then their sick leave rate would be $28 an hour. There's not an exact computation for how to do this, and obviously their time could vary between jobs from week to week, but you need to take some form of weighted average at least. The question that just came up is one that's not specifically addressed about differentials. So there are shift differentials in some workplaces. People that work on a second shift might get an extra rate per hour. I think it's fair to assume that most likely that type of increment would have to go into the sick leave pay if that's what that person normally works. And again, if they work the second shift sometimes and get that extra rate or that extra wage and work a different shift the other times and don't get that extra wage, then you're probably in that weighted average category. So again, that could become a complicated computation, and you may need to look into that further. There's also the issue of things like non-discretionary bonuses, and to what extent do those get calculated in as they would generally for the regular rate of pay for overtime purposes. It's not automatic that the regular rate referenced in this statute is the same as that defined for overtime law purposes, and the Department of Labor hasn't clarified that. So that would need to be reviewed on a case-by-case basis, and we would see how good of an answer we can come up with based on limited guidance and not a whole lot of explanation in the statute. It's kind of implicit in all of this is once people use this sick time, they then have the right to come back to work at the end of it, and they can't be retaliated against for either requesting or using their sick leave. So you can't just fire someone when they want to come back after 2 weeks off for being sick. You could do it if you had an independent basis, but you can't do it because they used the sick leave, which is, none of this is entirely a shocking concept. I mean, none of the general premise. A lot of employers already have sick time, paid time off, and what have you. And, for the most part, people don't think about firing somebody just because they went on vacation or took sick time or what have you. But that is one thing to keep in mind. If you do lump your sick time with other forms of leave and PTO, is you then, need to be careful that you're not treating someone differently for using PTO where you don't know whether it's vacation or sick leave or something like that, because then you could be seen as violating their rights under the sick leave law. Again, I think something like expecting notice for just a vacation versus a notice for a surgery or a medical situation or a domestic violence safe leave situation would probably be reasonable, though. I mentioned the unionized workplaces. The statute itself is clear on this. Well, I shouldn't necessarily say clear, but it's direct on it. It allows that employers and unions can negotiate an alternative to the New York State legal requirements on sick leave, but it also adds that these alternatives would only be valid if they're part of an agreement reached after September 29th, 2020. That is, say, on or after the September 30th effective date of the law. So if you've agreed to something else in a pre-existing collective bargaining agreement, then that's not going to do you any good as of September 30th, and possibly most importantly, as of January 1st, once employees start getting to take the state mandated leave law. The agreement with the union also has to specifically reference labor law section 196B, which is where the sick leave law has been codified, and the agreement has to provide a comparable benefit. So what does that mean? Well, the Department of Labor guidance that's out says that they consider leave time for which has fewer restrictions on its use to be comparable, regardless of the label of such leave, e.g. annual or vacation time, and multiple leave benefits which meet the use requirements of this law may be combined to satisfy the comparable benefit requirement. What does that mean? Again, I think it says if you had something like PTO, and as long as it's not more restrictive than what the state law requires, then that's fine. Again, I think that applies outside of the union context as well. And it also says that multiple leave benefits can be combined. Hypothetically, for example, you could have one domestic violence leave allowance and another sick leave allowance. If combined somehow, they would be sufficient. That could still be comparable, or personal leave and sick leave or something like that. So I don't want to get too much in the details of that. At this point, assuming there's some degree of latitude there if it's negotiated arm's length between the union and the employer. But again, it only helps if it's after the effective date of the law, and then it's specifically referenced in the statute to make it clear that the union and the employer knew that they were affirmatively opting for something different than what the law says. Briefly, the guidance notes that there are circumstances where the New York Paid Family Leave program could provide partial compensation, but which now an employee could potentially take sick leave and get full pay. The guidance says that employees can use paid sick leave during paid family leave only if the employer allows it. So if there is a situation where somebody applies for paid family leave to care for a family member, for example, and they would get the 2/3 pay, or roughly that, depending on how much they make, then you could allow them to use some sick leave to make up the difference. You in total can't exceed their full regular wages for a day between the two. And if you're going to do that, I suggest that you better have some policy explaining when you're going to allow that, or that you're going to allow it generally to avoid discriminatory application. You wouldn't want to allow it on an ad hoc basis for some employees, but not others for some reason. It's not entirely clear to me why an employer would object to the employee doing this. It seems like might as well just let them use up their time if they have it available. But I suppose you could come up with a theory that in some situation it makes somebody more willing or able to take leave if they're getting full pay versus partial pay. And you could maybe come up with some theory to not allow it, but for whatever reason, the state says it's the employer's right to allow it or not. As we're kind of wrapping up, I'm going to get back to some policy issues and then take questions. I just wanted to comment on the New York City paid sick leave law again. I'm not going into all details on that. It's been around for a few years now and was the basis for some aspects of the New York State law, but the New York State law is a little broader. For example, I didn't specifically state it in here, but the New York State law doesn't have any waiting period. So people that are hired start to accrue sick leave as of day one of their employment. As they start working hours, they start to accrue, or if you're front loading, then they get it front loaded. That was not the case in the New York City leave law. But that has now recently been amended by the New York City legislators to make the New York City law also satisfy the state law. If there is a conflict, then the New York State Department of Labor notes that the state law would prevail. That is to say, if New York City didn't meet the requirements of the state law, you couldn't satisfy just the city law and ignore the state law. If the city law, as it does in a couple of situations, requires something more than the state law, then you have to satisfy both. There are some extra domestic violence situations, I think, that are specifically covered under the New York City sick leave law that aren't in the state law. So if you're in New York City, you have to do that. New York City also has a couple of specific notice requirements that the state does not have. So again, you would also have to satisfy those in New York City. But the laws are much closer now because the city specifically modified its laws to come into compliance with the state law as well. Just a couple special case situations that the New York State guidance recently addressed. The issue of telecommuters. It says for someone who works outside of New York but sometimes comes into New York, you only have to let them accrue time for the hours where they are physically working in New York State. Talks about this again in the context of telecommuters. I don't know if that's just because of the coronavirus world we're living in, where so many people are working at home, and especially in the New York City area, the number of people that cross state lines. But if someone is working from home in, say, New Jersey, 90% of the time, but they come into the office in New York City the other 10% of the time, then they have to accrue sick leave that 10% of the time. The question earlier about employees who are out of state, do they count? I think they don't count unless they, for some period of time, physically come into New York State to perform work, and then they do accrue time. If you have employees around the country and some who just occasionally come to an office or some physical location in New York State, I think technically they accrue sick leave in New York State. You could then make the argument, but okay, you can accrue the time when you're working in New York State, but you can only use it when you're in New York State. That's a complicated scenario. So if you're in that situation, and it could actually be the request, that information has to be provided. It includes not only their current accrual and how much time they've used, say, this year, but in all previous years as well. All right, again, if you have questions, this is a good time to start putting them in. There's a couple after another couple topics I'm going to address just on this slide. I'll get to the question, leave in with other paid time off, which I think for a lot of employers that already were providing paid time off is going to be the preferred approach, shape, or form. If you have an employee handbook, you should modify that to include it, or issue it as a addendum or something like that. Even if you don't have a handbook, you should have a written policy that covers your obligations on sick leave, because there are aspects that need to be in writing. So address your accrual. If you're going to front load it, that makes things a lot easier administratively, most likely, but you then have a potential issue with the disparity between full and part-time workers, or full-time workers who, for whatever reason, aren't going to work enough to accrue the full 40 or 56 hours normally in a year. And, the issue of would I be willing to err on the side of over providing a benefit up front. I should note that technically you don't have to use the calendar year for your sick leave year. You could run it some other consecutive 12-month period. It's a little hard to think that out because the law happens to take effect on January 1st, but you could somehow set up a different year if, for example, you wanted to front load, but you couldn't afford to have a bunch of people using the time in January. There might be a way to structure that meets your specific circumstances. The use issue is primarily one where you define whether there is any minimal increment. Again, you can't generally say people have to give you 5 days notice before using sick leave. You can say they have to let you know before they use it. And you might, if you have a paid time off policy, be able to carve out vacation time versus sick time as far as that goes. Annual limits, though, should be in writing somewhere because, again, the statute itself does not dictate the 40 or 56 as an absolute limit on how much someone can accrue or how much they can use in a given year. It just says you can put those limits in place. So I would, unless you intend to allow something different. As far as payout, again, address what you're going to do upon separation of employment. That's critical, especially if you don't want to pay it out. And then there is the concept in some existing policies of payout, for example, at the end of the year, or arguably even at any time that the employee asks for it. The law doesn't say anything about that or suggest that you have to do that. But again, it's something to consider whether for some reason you should. And then finally, I've kind of noted a couple of times there is an interaction with other leaves. That's something that if you are covered by the FMLA, for example, and most of you are covered by New York paid family leave, you should consider putting something in the policy to say, for example, if you want to use paid sick leave while receiving New York paid family leave benefits, then you can or you can't or whatever that might be. Again, it's not very obvious to me why you wouldn't want to allow them to do that. And then don't forget that you should, in cases where the sick leave counts for FMLA, allow them to use the sick leave while also designating it as FMLA leave. Although the state says you can't require confidential medical information as a condition of using the paid sick leave, you can ask for it if you are subject to FMLA in the form of medical certifications, and the federal leave law should, in that respect, trump the state leave law. So as long as you're asking for the information not to decide whether or not they can use your sick leave, but for purposes related to designating it as FMLA leave or not, you still have the right to get that documentation. Again, these are not every possible policy issue that you might have, but they are some that come up frequently and some of the ones that should minimally be addressed in a policy, as well as noting how many hours and that type of thing. All right, now there are a few questions. Type them in if you haven't already. Just want to let you know, if you're registered for this webinar, then you are likely already on our newsletter, either because you already were and that's how you heard about the webinar, or because in registering for this webinar, we've added you. You can always take yourself off if you don't want to stay on there, but that comes out monthly with information, including likely information if we find out there are additional regulations coming forth from the Department of Labor. And for the most frequent updates, because we don't want to clutter everyone's inbox, you can follow us on LinkedIn and we will post as fast as we hear about something, at least, a link to where you can get more information about something that might be of interest to employers in New York State. So I'm going to start answering some questions. While I get that loaded up, let me give you the link to the slides for those who want to be able to access those. Like I said, you should get an email that will have a link to them tomorrow anyway. And then if you don't have time to stay on, here's how you can contact me after the fact with any questions you might have in follow-up or ones that you don't feel like asking in this forum. We talked about employees versus independent contractors earlier. There was a follow-up question about what about partners who get a K-1? So owners of the company would generally not qualify as employees, but that's not a one-size-fits-all answer. There are arguably people that are treated as partners, even that get K-1s, who might be able to make the case that they're employees. So unfortunately, you would have to look into that more specifically on your, as long as they do get it annually, I think that would be okay. There's another question. Can an employer mandate the use of New York State paid sick leave if an employee does not show up for a scheduled shift with no explanation, or if an employee reports to their shift an hour late without explanation? The interesting thing about that is whether you would really want to do that in that situation. Remember, if you mandate their use of the sick leave, then you can allow them to use the sick leave, and it's not obvious why they wouldn't want to. Again, I can imagine hypothetical situations. I want to save my time or what have you, but if they don't give any indication that it's for a situation that's covered by the sick leave law, I wouldn't count it against their sick leave utilization. If you had a broader paid time off policy, then arguably you could require them to use the time more easily in that situation. But again, be careful with whether you want to. Question back on the telecommuting. And yeah, this was really bizarre because this was in the guidance. The statute didn't say anything about it. This says it's still unclear about those who are telecommuting outside New York State. Are they able to accrue sick leave time even though they are working outside of New York State? I think the statute or the Department of Labor is saying that you don't have to accrue, that you don't have to let them accrue for time they're working outside of New York State. But there's nothing stopping you from letting them accrue. You can let them accrue all at once, or one for every 4 hours worked, or no matter where they work. So again, the way you're asking a question, the employer can allow them to accrue sick leave for time working outside of New York State, but the Department of Labor seems to be saying pretty clearly that you don't have to. This question says, our full-time employees have a PTO policy more generous than what is required, and we plan on lumping the sick and vacation hours together front-loaded. For part-time employees who never received PTO in the past, should we only allow part-time employees using accrual method to use the paid sick leave for the specific items provided by the state? And can we write a policy that the hours earned by a part-time employee does not get paid out at termination? The last part is easy. Yes, you can write a policy saying hours earned by part-time employees don't get paid out at termination. So that's the easy part. As to what you want to allow your part-time employees to be allowed to use the time for, that's really up to the company. As long as you allow it at least for all of the items covered by the paid sick leave law, you're fine. Again, the practical issue being that you might not always get the information that you would ideally like to prove that it meets one of those requirements. So you could suspect some over expansive use of sick leave perhaps at the margins. Whether that's enough to tip you into just saying, let's just call it PTO, you can make your own call, but there's nothing stopping you or requiring you to do it one way or the other. Here's a good question. Is there a sample policy out there anywhere? I'll just be honest and say I haven't seen one. The state didn't put one out, or at least they hadn't as of last night. Whether they yet will, I don't know. My suspicion is that the state probably assumes that a lot of companies already had policies and others are going to do things like PTO policy versus sick leave. And the combination of those considerations might make it unlikely that the state wants to put a policy out. The other consideration there is that there are a lot of ambiguities in the statute that really can't be easily reconciled. And I'm not sure how quick the state wants to be to take a position on those. So short of coming out with a really vanilla policy, it would probably be hard for them to do. And the other thing to keep in mind is, unlike the paid family leave law, which specifically required employers to have a policy, and in which case the state did come out with sample policies, and the sexual harassment policy requirement, the same thing. There is no specific statutory requirement here that you have a New York paid sick leave policy. There are just related factors that suggest that you better have a policy, or at least somehow put these things in writing, or else you're not going to be able to accomplish what you think you're going to accomplish. So if there are any other questions, I'm happy to continue to answer them, but I don't see any more at this point. If you are still taking the time, I know this is complicated. I know there's a lot of other things going on, but it is a requirement that the state has put in place that everyone's going to have to be on top of by January 1st. If there is additional regulatory guidance, that would be great, and we will do what we can to share information about that, like I said, through our email and through LinkedIn posts. And I just wanted to also note that there's no absolute obligation that the state issue formal regulations. The Commissioner of Labor is given the right to do so by the statute, but there's not a specific direction to do so, as there has been, again, in some of those other situations. Like the paid family leave, I think the various state agencies involved there were required to issue regulations, and I believe the Department of Labor was required to issue and covered. Then I'm glad I was able to provide this information, and hopefully it was helpful anyway. All right, so thank you and have a nice day.